Hi, everybody. It is 8 on the East Coast, so we're going to get started because we want to leave a lot of time at the end, hopefully, for Q&A. Thanks for joining us tonight for our webinar on the shadow/emergency docket in OT 25. Thanks so much for joining us after a long day of teaching or maybe a long day of snow day with your own children. So thanks for being here. I'm Kathy, and Emma's going to drop my email into the chat. Please feel free to reach out to me if you need anything after this webinar. That's my very long title. Before coming to street law, I taught for 27 years in Fairfax County Public Schools, and now I've been at street law for a little over 7 years. So I'm going to be your moderator tonight. You're probably already pretty familiar with street law since you found this webinar, but just in case you're not, we are a nonpartisan, nonprofit organization, and we work to try to make sure that there is law-related and democracy education in the world. And here's our disclaimer that we are a nonpartisan organization and the views of our guests are their own, and this program is offered for educational purposes only. If you want to know more about street law, I don't want to take a lot of time here to give a lot of details, but you can check us out at streetlaw.org. So I'm rushing to get to the good part, which is to introduce our legal expert tonight, Steve Vladeck. We're very lucky to have him. He is a graduate of Yale Law School, where he was the executive editor of the Yale Law Journal. He clerked for both the Ninth and the 11th Circuits. He's argued before the Supreme Court and many other courts, both civilian and military. He is currently a professor at Georgetown University Law Center. And he is probably most famously the author of The Shadow Docket, which is a book probably most of you know about. If not, check it out. I've both listened to it on Audible and read it. So that's my well-worn copy. He is CNN's Supreme Court analyst and editor of a newsletter that I get all the time, One First. It really helps me keep up with what's going on at the court. And also, you've probably seen him on a lot of your favorite podcasts. So I know that you're a regular on Strict Scrutiny. And I saw you live at the Strict Scrutiny Live DC show last year, actually. So I'm going to throw it over to Steve and let him tell you important things that I missed in the intro.
Only that that picture is way too old. But it's Kathy, it's a real treat to be with you. Part of why I wrote the book in the first place, and part of why I have this newsletter is because I really do think that it's so important, especially now, to have public accessibility to what the Supreme Court's doing, especially when, as is so often the case these days, some of the most important stuff the Supreme Court is doing is technical and procedural and messy. And so it's a treat to get to join you and our audience tonight.
Great. We can't wait to learn from you, and hopefully there'll be lots of good questions for you to field towards the end.
I'll just add one quick thing about the audiobook, which I put in the chat. I auditioned to read the audiobook, and I found out that I didn't get picked when they sent me the three finalists, and I wasn't one of them. So that was awkward.
Oh, that's really funny. That's a great story. Okay, so I'm going to start out just by making sure, because we're going to use this term a lot, OT 25. It's in the title of our webinar, that we're all on the same page about what OT 25 means. I always find this term, the October term, and then the year a little confusing because most of October term 25 is going to happen in 2026. So I think that can be a little confusing. It's named October Term 2025 because oral arguments begin on the first Monday in October. That is standard every year. And so that's the name of the term because it starts on the first Monday in October. This one started October 2025. Oral arguments will happen the whole way through April, likely. Sometimes a little later. We had a late one last year, but that's typical. And then you start having decisions for OT 2025 start to come down, and some came down this year in November, although those were not like fully decisions with full opinions. Um, there are, a couple came down on the 20th, so they're starting to trickle down now. You never know when a decision's going to come down. The parties in the case don't even know. So that's not on no set schedule. They usually end at the end of June, but a couple terms recently, they've gone into the very beginning of July, which I think makes the justices a little cranky because they usually have vacation plans immediately after they hand down the last decisions.
So
Um,
do I, for what it's worth.
they're right, and all the journalists, and you're right, everyone thinks that that's when it's going to happen. If you look at that line for granting for certiorari grants, that means when they start taking cases for the current term, you'll see that the blue line turns red right about now in January, and that's because most of the cases they take from here on out will get actually added to the docket for October term 2026. Although there are exceptions to that, like there are to almost everything. Yeah, so just wanted to let you have a visual of what we mean when we say October term or OT 25.
Can I just add one
Anything?
quick note on that,
Oh,
Kathy?
yeah,
Just
absolutely.
I actually think this will be relevant to what we talk about later. So the timing is set by a federal statute. It's 28 USC Section 2. And it's a good reminder of a very nerdy point that doesn't really matter here, but will matter later, which is that actually almost everything the court does is controlled directly or indirectly by Congress. So the fact that the court's term starts on the first Monday in October is just something Congress agreed to and wrote into a statute back in 1916. There's even a famous episode from the very early years of the Republic, right about the time of Marbury versus Madison, where Congress changed when the court sat in a way that prevented the court from sitting at all in the entire year of 1802, which was a way of messing with the court. And so, as we'll come back, I think, at various points tonight to the relationship between Congress and the court, it's a good reminder that even something as banal and sort of procedural as when the court sits actually is something that Congress set in the first place.
That's great. Thank you. Okay, I'm also just gonna pre just do an overview of the merits docket because this is just sort of to contrast because what we're going to be talking about tonight are cases that are not on the merits docket. So just to make sure that we understand what it is so we can understand what those other cases are not. So the merits docket is pretty much all the cases that you teach to your students came up on the merits dockets. All the landmark cases, even Bush v. Gore it came up originally on the emergency docket. There was a request for a stay, but the actual case was on a merits docket, even though it was expedited. So almost all the cases you teach perhaps are merits docket cases. So these are the cases that go through the regular procedure. So the person who lost at the court below files a petition for certiorari. It's very hard to get a case granted. Only 1% of cases are granted. And then once the case is granted, they are fully briefed. So the petitioner, the person who asked the court to hear the case, has a certain amount of time to file their brief, and then the respondent gets to read their brief and do their own brief, and then their reply brief. So this back and forth takes months where it's fully briefed. And then there are oral arguments. So they get their day in court and stand up and argue before the justices and take their questions. Typically, there are months before a decision comes down, although that it can be faster, but it generally takes a long time. And that's because while the justices are writing their opinions, they're circulating them back and forth, and sometimes there are changes and things like that. So the whole opinion writing part takes a really long time. These decisions, except for during the pandemic, are generally handed down from the bench. So not only does the person who wrote the opinion for the court get a chance to summarize it for the people in attendance, if someone feels really passionately about a dissent, sometimes dissents are read from the bench. And then the opinions are available in writing and online these days. And those cases set a precedent for future cases. So these are the sort of like when you look in your textbook and it says how a case goes through the Supreme Court and it's all of this, that's a merits case. Okay, Steve, what would you like to add to that?
Just that I was trying to find a link to it, but I couldn't find one that wasn't paywalled. There was a story actually in Law 360 today about how much the court's merits docket has shrunk. So, when I was in law school 140 years ago, back in the early 2000s, the court was still hearing about 85 to 90 of these so-called merits cases a year. That number sort of slowed down a bit into the 80s and high 70s in the early years of the 2010s. These days, the court isn't even hitting 60. And so, it's a relevant data point that the merits docket is actually down in volume, gosh, 20% over 15, 20 years ago, and even more over a longer period. Just to put the matter directly, the court's deciding fewer merits cases each year right now than at any point since 1864. And I suspect it doesn't feel that way because the court is in the news all the time. But I think there's actually an odd correlation between those two developments that I know we'll talk about a bit tonight.
Great. And just right on cue. So the numbers just super briefly for the merits docket is technically there are 63 cases granted, but four were decided without oral argument. So all of those things I just told you about, they didn't go through. So we're really 59 cases that have been will be fully argued. And probably any merits cases granted from now on out will go on OT 26. But there are always exceptions to that. I mean, there could be an exception to that. But likely we're going to hit about the 59, depending on how you count it, 59 or 63 this year, to Steve's point. Okay, now we're into the meat of what we're here to talk about. So you're going to hear a lot less from me and a lot more from Steve. So Steve, tell us what we need to know about the history of the shadow docket and this whole emergency slash shadow docket. After we talk about this, we're just going to call it the shadow docket because it's easier and that's the name of your book. But I think a little bit also about the debate about how we should be naming this thing that we're going to talk about.
Sure. I mean, so let me start with the term, and then we can sort of break it apart. So, as the slide notes, the term was not coined by me. I did what all good authors do. I stole. It's not really true. Will gave me permission. But in 2015, Will Bode, who's a conservative former Roberts clerk who teaches at the University of Chicago Law School, coined the term, Kathy, not just to cover emergency applications, and we'll talk a bit about what those are, but actually really to encompass everything that the Supreme Court does other than the merits docket. So it was basically the shadow docket was the negative space of all of the Supreme Court's work besides the 55 to 65 signed rulings and argued cases that the court hands down each term. And one of Will's, I think, really important insights was that a lot of important stuff happens in the shadows. He did not mean the term shadow docket pejoratively. He really meant it as just this evocative shorthand because there's a lot of sort of secrecy that surrounds what the court does off of the merits docket. There's not a lot of writing that accompanies what the court does off of the merits docket. And so the term really started as this just catch-all for everything from, which cases the court decided to take and not take to, procedural things about the timing of oral arguments. I mean, to, a whole slew of stuff. The sort of one of the sort of innovations that Will came up with is, because the Supreme Court these days has control over almost all of its merits docket, there's a lot of discretion baked in to how the court decides which cases to take up and which cases to not take up. And even all of that is something that we don't teach and study about enough. I mean, Kathy, you probably see the headlines every spring. Supreme Court unanimous in 34% of cases. Well, the statisticians would call that a real selection bias problem because those are the cases that justices are choosing to decide. Hey, look, we picked some cases where we all agree. Who knew? So the idea was that if we paid more attention to the rest of the court's work, we would have a more holistic understanding of what the court was up to. That was the original plan. And then round about 2017, a particular subset of the shadow docket really came into much more public light, and that was emergency applications. So being a big nerd, I actually don't use the term shadow and emergency docket interchangeably. To me, the emergency docket is a subset of the shadow docket. But one of the ways I can tell folks who are criticizing me online who haven't read my book is they don't understand that distinction. Um, so the emergency docket. So now I have to be a bit of a nerd on the legal side. Um, a lot of times when a litigant goes to court and is trying to get an injunction, is trying to stop either the government or a private party from doing something immediately, whether they win or lose, they'll appeal quickly. But there's this antecedent question of what should the status quo be for the duration of the appeal. It might take 6 months, it might take 2 years for the case to get all the way up to the Supreme Court. And Kathy, oftentimes it's really important to figure out, will the thing I'm challenging be blocked for the whole duration of my appeal? Will it be allowed to go into effect for the whole duration of my appeal? That's where emergency relief comes in. Emergency relief is when a party asks an appellate court to suspend the effects of a lower court ruling for the duration of the appeal. So to sort of put this into a contemporary context, a lower court blocks, say, an executive branch policy, right? An emergency application asks the appeals court, the Supreme Court, to put the policy back into effect for the duration of the case. Not permanently, right? This is why Justice Brett Kavanaugh likes to call it the interim docket. But as we've seen, these rulings can have pretty immediate, immense, and sometimes irreparable effects. So that's where the terminology comes from. Do you want me to take a minute on the history too?
Yeah.
Okay. So historically, yes. So time sensitive, because if the what separates out emergency relief from the ordinary appeal is I need relief now, meaning I have some argument that without getting immediate relief, I'm going to suffer what the courts call irreparable harm. Not just harm, but harm that can't be fixed if I win this case 2 years from now. This is why, for example, you don't see a lot of these with damages cases. You can always get money later. It's injunctions where we see most of these. And so I think it might be helpful to break the history here into two chunks. The old Supreme Court, so all the way up to 1980, the court dealt with emergency applications in one of two ways. If it was a really, really important case, the court would just actually hustle up and hear it on the merits. And there are a handful, like really just a handful of cases over the 20th century where the court did this. The Nazi saboteurs case during World War II, the steel seizure case during the Korean War, the Watergate tapes case, the Iranian hostage, like once a decade. Otherwise, until about 1980 or so, all emergency applications were resolved by the circuit justice, the one justice who had geographic responsibility for that particular chunk of the country. And that one justice might hold oral arguments in chambers or maybe even not in chambers. Justice Douglas was famous for taking over the local courthouse in Yakima, Washington, near where he spent his summers. They might write like solo in chambers opinions. And so the parties could get a lot of process. But Kathy, no one ever confused a single justice ruling for a ruling of the full court. That changed in 1980, and it changed mostly because of the death penalty and the Supreme Court's reinstitution of the death penalty in 1976 with a whole bunch of new rules. Well, all those rules had to be litigated by the thousands of people who were already on death row, and that led to an enormous flurry of not just important emergency applications, but like very like sensitive ones. And so the court basically pivoted from this single justice model where you had arguments and written opinions to a full court model where the norm they borrowed from was granting and denying plenary review, where they don't write, where they don't have arguments, where they don't file opinions, and where they would grant or deny relief, typically, Kathy, in summary orders that didn't provide much, if any, in the way of analysis. That shift really started in the early 80s with the death penalty, but everyone thought it was just about the death penalty. And so no one made a big deal out of it outside of the capital defense bar. It's not until about 2015 or so that the court starts taking these same behaviors, not having argument, not having full briefing, not writing an opinion, not signing the order, and applies it to nationwide policies. The first really big example, we're coming up on the 10th anniversary, was a 5-4 ruling in February 2016 in which the court blocked President Obama's Clean Power Plan. That was really unusual in 2016, and now we're seeing more and more of these all the time.
Good. I wrote on this slide unanimous per curiam opinions, and you sort of mentioned it with a different term. But can you tell us what that is? Because it shows up in the textbook, and I think some places I've even seen it in the textbook. Um, maybe in some textbooks maybe misdefined. So can you tell us what a per curiam opinion is? There's obviously a little example there on the
Yeah,
slide.
and so I'm going to put into the chat actually a link to a post that I wrote for my newsletter that walks through all of these details. But let me just do this briefly. Per curiam, when the Supreme Court uses it, and other courts use it differently, when the Supreme Court uses it, it just means unsigned. It does not mean unanimous. It could, Kathy, it could be unanimous, but you can see a per curiam opinion sometimes that has dissents, even four dissents, which is really striking. So per curiam opinions are what we usually get, and the one you have on the screen is a good example. When the Supreme Court does one of two things, when it resolves a case at the certiorari stage, and this is the one you have on your screen as an example of this, basically, this case is so easy, we can resolve it summarily without granting cert, without plenary review, without oral argument. That's one track. That's rare. We only see a couple of those every year. Or on one of these emergency applications, in the handful of cases where the court writes a majority opinion, it is invariably per curiam, meaning we don't know who wrote it.
Okay, so people I'm sure are trying to figure out how does the court, how do advocates know whether the case should come up on the merits docket or the shadow docket? And before you didn't use the word stay, but I think you were sort of talking about
Yep.
what a stay is. We're going to hear that term a lot, I think, and we hear it a lot in the news. So a little bit about what a stay is.
So let me start with the first question. So a merits appeal is sort of to make a long story short, when a party is asking the Supreme Court to take up the entire case and reverse or vacate what a lower court did in their case. So basically, the lower court said we lose, we think we should win, and that should be the end of this case. That is how most of the merits cases the Supreme Court decides go. There are a couple of maybe we win, therefore we win on this procedural question, therefore we can go forward in the trial court. Doesn't mean the whole case is over, but like we should have won, we lost. A stay is back to that emergency relief, not we should win, but 2 years from now, we are likely to win when we're ready to appeal, right? When we're allowed to appeal. And because we are likely to win 2 years from now, you should right now freeze the lower court order. So a typical stay is when a lower court has issued an injunction. So let's imagine a federal judge in Washington, D.C. Issues an injunction, a coercive order that blocks the federal government, let's just say from enforcing the birthright citizenship executive order. Um, that appeal, Kathy, could take time, right? First, it has to go to the D.C. Circuit, the Federal Appeals Court. They're going to have months for briefing, months for argument, maybe a year for the opinion, and then to the Supreme Court. But right away, the subject of the injunction here, in my hypothetical or not so hypothetical, the Trump administration wants to go right up the ladder and have the injunction stayed, not because we're going to resolve the full case right now, but because we think it's likely enough that we're going to win 2 years from now, and we're being harmed in the interim, that you should give us this extraordinary relief.
Okay. And I was going to ask the second part of that question, but you basically just outlined it, which is the sort of three-pronged test that the court is going to look at when they decide whether or not they're going to grant a stay. Is there anything more you want to say about that?
Just that, I mean, I think it's really worth playing up the third part of this. So the lawyers have a term called balancing the equities. And that's really an important part of what is supposed to happen with regard to emergency applications, meaning it's not enough to show, it's a prerequisite that you show that you're likely to win. So if you're not likely to win, why are we doing anything? But it's not enough. It is necessary, it's not sufficient. Because just the fact that you're likely to win 2 years from now is not enough in almost every case for emergency relief. You have to show us that there's some reason why we should, move heaven and earth and depart from our ordinary process here. And that's really where it's not just, Kathy, a question about will you suffer irreparable harm if we don't? It's also, is your harm greater than the harm we would inflict if we did? So that's the balance. The balance is not just are you harmed, it's are you harmed more by the lower court ruling than the other parties would be if we did what you asked us to.
Okay, so I'm just going to do a quick overview because then Steve's going to get into some of these subtitles of what or sub genres of what is on the emergency docket right now. And so Steve mentioned the fact that the death penalty cases are a big part of it, and they still are. We rarely hear about them, occasionally one or two, but they usually aren't making news. And they you can see um, that usually they are denied. There were only three granted this year, this term so far. And then of the non-capital cases, right now there are five pending, 31 have been already decided. And you can see, it's much more even, 11 granted, 18 denied. So it isn't as lopsided as the death penalty cases. The federal government has fared pretty well, and we can talk more about that as we go on through the categories. And two were withdrawn. So this is really small. I know I'm going to show the same information in a different way with a different visual in the next one. But you can see at the top of this list are the kinds of cases that are making up these non-capital cases. So cases, and I just lumped them together as sort of made sense to me. If you were going to do the same activity, you might come up with a little different groupings. But deportation and immigration cases atop the list, and then cases about funding and termination of grants, the firings, enforcing settlement judgments, which is not something we usually hear about. Transgender rights, those cases were just heard last week. And then it goes down from there. So this is that same information just in a visual. So you can, I guess, see pretty clearly that what is making up the docket this year. So a lot of sort of miscellaneous one-offs, but there are definitely some categories that we can see sort of coming rising to the top here. Anything you want to say about this before we move on to
I
the
think it's
next
worth
one?
putting into a bit of historical context how insane the numbers on your last slide were. Out of context, it's like, okay, these numbers, they're interesting. But like these numbers historically are just preposterous. And so just to take one example, um, if we just look at emergency applications by the federal government, the most common litigant in the Supreme Court, the most respected litigant in the Supreme Court, and Kathy, the one that's most likely to have grounds for emergency relief that the justices will buy. Um,
Mhm.
During the entirety of the George W. Bush and Barack Obama presidencies, two, I think we can all agree, slightly different two-term presidencies, the Justice Department filed a total across 16 years of eight of these applications. Right. Whereas there's the chart. Right. Whereas during the first Trump administration there were 41, but then during the Biden administration there were 19. So we went up and then we sort of stabilized a bit. Kathy, as you know, in the first year of the second Trump administration, we've had 32. Which is just, math is hard, I know. But we went from 8 in 16 years, so once every other year, to 32 a year. That is a 64-fold increase. These are, especially when it's the federal government asking, these are not frivolous cases. These are not cases that the justices dispose quickly. And it's really stunning, whatever else you think about the court's behavior, we'll talk about some of it. Just the volume has totally swallowed the court in ways that weren't even true when I wrote the book.
Come back to here. Okay, so another way to look at this, so I put those into categories by sort of subject matter, but as you sort of just alluded to, another way to look at this is how many of these cases are about executive power in some way, shape, or form, with a lot of different subject matters, but they have something to do with how much power the executive branch has, and not just the president himself, but the executive branch as a whole. And you can see that it's noted here. I mentioned in one of the last slides that the federal government has fared pretty well. You can see which ones have been granted. The one that was denied, probably most people have heard about that one. It was the federalizing of the National Guard case. And two that are still pending, that both have to do with firings. So, what should we know about this specific subset of the cases that are before the court this term?
So it's hard to generalize, but if we just take the firing cases, I mean, one of the biggest questions that the court actually has on its merits docket this term is a question that started as one of these, as well, three of these emergency applications, which is, there are all of these agencies in the executive branch that have historically been called independent agencies on the ground that at least their heads are protected from being fired except for cause. And so the independence comes from the idea that the president can't just remove them for political reasons. Well, the Supreme Court really, really wants to overrule the 1935 case that basically set the precedent for those kinds of for cause removal restrictions, a case called Humphrey's Executor. And one of the really striking things about Trump versus Cook, about Trump versus Slaughter, about Trump versus Boyle, and a case that's not on the slide, but that's also tied to all of them called Wilcox, is Kathy, you had all of these lower courts, saying, hey, Humphrey's Executor is still good law. The Supreme Court hasn't overruled it yet. And then you had the Supreme Court staying those rulings on the ground that they might soon overrule Humphrey's Executor. And so the charge that Justice Kagan especially has leveled in her dissents is that the court is in such a hurry to get rid of Humphrey's Executor that it's rewriting the separation of powers because it is allowing the president to basically violate statutes without striking those statutes down. And it's allowing the president in the interim to, put people who will do his bidding at the heads of all of these independent agencies. Maybe that's what the court would have eventually done on the merits docket, but Kagan's objection was doing it through all of these emergency applications. An objection she also leveled in the AIDS Vaccine Advisory Coalition cases. There were two of those, where the court, through a stay, allowed the president to basically not spend hundreds of billions of dollars of basically foreign aid spending that Congress had mandated. So, what's really striking about all of the cases you have on the slide and a few others is how much they've all followed this pattern of lower courts blocking the executive branch on grounds that the Supreme Court hasn't yet said were wrong, and the Supreme Court letting the executive branch continue to do the thing that the lower court said was unlawful.
And does the lower court have an obligation to follow the Supreme Court precedent? I mean, did they have any discretion there?
So, I mean, this is what's tricky, right? Which one's the precedent? So, the Humphreys Executor cases are a good example of this. The lower courts are required to follow Humphreys Executor until the Supreme Court overrules it. And so, I'm a neutral district judge in one of these cases, right? Even if I think the Supreme Court might overrule Humphreys Executor, I can't do it for them. So I'm bound to apply Humphreys Executor. And I issue an injunction because I'm bound to apply Humphreys Executor. And the Court of Appeals, also bound to apply Humphreys Executor, denies the government's application for a stay. And then the Supreme Court issues a stay. And so, a stay basically on a ground that the lower courts could not have reached. It's hard to figure out if you're a district court what you're supposed to do in those cases. And I know we're going to get to this in a bit, but one of the things that really has been the icing on the cake is in some of these cases, the justices have expressed frustration, if not outright hostility, towards some of the district courts, when I think the district courts are in a pretty sticky position already that's exacerbated, Kathy, by how little the court is writing. Just to take all of the cases you have on the screen here, none of those cases produced an opinion of the court, right? None. There are a few of them that have like a 1 or 2 page order where there's like a cryptic explanation from the Supreme Court for what they're doing. But the court is both using these rulings with massive real world consequences, not explaining them in very much detail, and then getting mad at district courts for not reading the tea leaves correctly.
Yep. So I just have to put in a little plug. I told Steve I was going to do this, that if you're interested in these cases that deal with executive branch power at the court this term, both the merits cases, because there are some, and these shadow docket cases. We did do a webinar 2 weeks ago on exactly that, and Emma will drop the link into the chat so that you can watch that on YouTube if you want to. Okay, I said to Steve that on that list there were two cases involving schools, and that we were going to get a question about it if we didn't just talk about it because you all are teachers and you're probably interested. So these are the two cases. Steve, anything to say? One has been already decided and was denied just last week, or I guess maybe that's 2 weeks ago now, and one is still pending.
So the Mirabelli versus Bonta is actually one of the, I think, three significant emergency applications that's currently pending in the Supreme Court. It has become almost a full-time job just to keep track of all of these applications because there are just so many of them these days. Um, and I guess the thing I'll say about Mirabelli is that the Supreme Court, especially Kathy, over the last really year, I mean, going back to last term, has had this remarkable dichotomy where in non-Trump cases, it is really relying heavily on what we talked about earlier, the traditional balancing of the equities, where there are cases in which it looks like a majority of the court may well be sympathetic to the plaintiffs on the merits, but where they don't go out of their way to grant emergency relief because they don't think that there's a sufficient irreparable harm. So one example from earlier this term, or I guess late last term, was a case about Mississippi's age verification law for social media, where the court left that law in place. And Justice Kavanaugh wrote a concurring opinion saying, I think the law is probably a violation of the First Amendment, but I don't think that we need to step in now because I don't think the harm is sufficiently irreparable. The same thing happened in September in a case about South Carolina trying to prevent a single transgender high school student from using the bathroom that corresponded with their gender identity. The court said, "Well, we're taking this up this term, but South Carolina is not irreparably harmed by allowing one student, right, to use this bathroom." So my take on the Mirabelli versus Bonta case is I wouldn't be surprised if that's where this is heading as well, where we get some sort of sympathetic order on the merits, or maybe a separate concurrence from Justices Alito and Thomas and Gorsuch, that is very sympathetic to the plaintiffs who are challenging the California state law, but where the disposition is ultimately to deny emergency relief. And I don't know that that's wrong, Kathy. What's striking is the sort of disconnect between the court relying on, applying, following the traditional equities balancing in non-Trump cases and not doing so much of that, right, in all of these Trump cases. That's really been one of the most frustrating, from my perspective, features of all of these emergency docket cases.
Great. Okay, so what are the other cases that you think are really going to be consequential this year or have been? So we saw that there are actually only five pending. So most of the cases that we've been talking about being on the shadow docket are have already been decided.
Well, one of the both great and horrifying things about emergency applications is you can't predict them all the time. And so, it is, I mean, the court usually clears its merits docket by the end of June, but Kathy, the emergency applications can go all the way into September. And we saw that last summer. I guess I'll just say, I think I would take, I would highlight three, well, four that have already happened that have been super consequential, and then let me say a couple of things that are coming. So on the super consequential side, I would say in the Trump cases, one, the allowing the president to cancel all that foreign aid spending. It's technical, it's nerdy, it's not even something that I think lawyers who don't fully understand congressional appropriations can wrap their heads around. But that was actually from a pure impact perspective, Kathy, a massively significant ruling because of just how much it allowed the president to continue doing so much of the non-spending and the grant cancellations and all this other stuff that I'm not sure at the end of the day are actually legal. So that's one. Two, and this is closely tied to the horrifying events of Minneapolis over the weekend. There was a case in September where the court, in an unsigned, unexplained order, blocked a Los Angeles district judge's ruling that had stopped ICE from stopping people, arresting people based solely upon the color of their skin, whether they spoke Spanish or English with a thick accent, where they hung out, and what kind of work they did. That was what this court said. It can't just be any of those factors. You need other reasons to stop them, and the court blocked that, which I think is, not impossibly sort of inseparable from how much more aggressive ICE has been since September. The third, and I think probably one of the bigger losses for President Trump, was in December when the court blocked his effort to deploy Illinois and Texas National Guard troops into and around Chicago. Speaking of ICE, that was obviously, I think, a very big deal in the moment. And then the fourth is actually a non-Trump case, also in December, when the court blocked a ruling by a federal district court, indeed by a Trump appointee, that had held that Texas's effort to redraw its congressional districts was an unconstitutional racial gerrymander. The court froze that ruling and basically allowed Texas to use its new map for the 2026 midterm cycle. So pivoting to what's pending, I mean, there's actually now a pending application in California, basically where the plaintiffs, who are now Republicans, not Democrats, are raising the same racial gerrymandering claim. This time, the district court did not buy it. And the plaintiffs are asking the Supreme Court to actually find for themselves that this was a racial gerrymander and therefore block California's new map. Kathy, it would look awfully bad if the court that went out of its way in December to put Texas's map back into effect were to go out of its way in February to block California's map. I mean, the charges of partisanship, I think, would be very hard to rebut in that context. So that's one of the ones I'm keeping my eyes on. I also think it's entirely possible that, sooner rather than later, some of this litigation in Minneapolis makes its way to the Supreme Court. Whether it is, the efforts by protesters to get ICE to stop following them, whether it's this remarkable and, I mean, fairly unprecedented lawsuit by the cities of Minneapolis and St. Paul and the state of Minnesota, arguing that some of the ICE deployments are a violation of the 10th Amendment. Whether it's this even smaller case where the chief judge in Minneapolis has ordered the acting director of ICE to show up in person to testify. Just whichever one it is, it's hard to imagine that that won't somehow get to the court. But just the last thing to say, Kathy, is this is an administration that, for better or for worse, creates drama. And, you might like the drama, you might hate the drama. It's hard to doubt that it's drama. And drama tends to lead these days to emergency applications. So, I think the reality is that by pure calendar terms, we're only about 3.5 months into the term. And I think that there's a lot of big emergency applications that we can't even imagine yet that are going to get to the court between now and, the first Monday of this coming October.
Do you think there's a possibility that one of the things that might bubble up out of Minnesota is the exclusion of the state and local law enforcement from investigating what's happening? It's so sort of a federalism angle.
It's very possible. I mean, so that case, I think the real question there is, in that case, the district judge, also a Trump appointee, late Saturday night granted a temporary restraining order. And I think it'll be interesting. One of the things, Kathy, that I think we don't talk about enough when we talk about the courts these days is that the Trump administration has been very savvy about which cases it is appealing and which cases it's not appealing, and about which cases it's going for emergency relief and which ones it's not. So, to look at the Trump administration's track record, I mean, you had it on a slide a couple slides ago. The administration has done very, very well on emergency applications in the Supreme Court, but they are picking them. And I think, they're being very strategic about not taking cases to the Supreme Court that they don't think they're likely to win. So that might include the TRO that says, don't destroy evidence when they're already not allowed to destroy evidence.
And can you explain what a TRO is real
I'm
quick?
sorry. So a temporary restraining order is basically like a super preliminary injunction. So a preliminary injunction, which is what most of these cases involve, is basically early in the litigation, the judge says, hey, stop doing that for the rest of the litigation. A temporary restraining order is even earlier. A party goes to court and says, judge, something crazy is happening. We need you to stop it right now before you even hear from the other party. The sort of closer to ground, Kathy, there are too many domestic disturbance cases, right, where a TRO is actually really necessary because you need a restraining order against, say, a violent partner or former partner or family member. without, telling them that you're getting a TRO. So TROs are often the very, very first type of emergency relief, followed by preliminary injunctions. Usually it's the preliminary injunction that then goes up for the emergency relief conversation.
Good. I'm going to hurry this up a little bit because I want to get to
Yeah.
participant questions. And I think you've hit on some of this, certainly the number of applications from the federal government before, but anything else we should know about the way maybe the things are changing and the way that it's being used?
So, I mean, I think the volume is a huge story unto itself. I would add that, like, related to but distinct from the volume is the effects of these rulings. I mean, if you compare the first Trump administration, and your slide has, there was a lot of volume,
Mhm.
excuse me, during the first Trump
Bless you.
administration. But Kathy, those cases were much smaller. The cases from the first Trump administration is like, can we put this one particular immigration policy back into effect? Can we execute this one federal prisoner? Can we prevent the Secretary of Commerce from testifying in this one lawsuit? The cases of the last year have been, can we deploy the National Guard in Chicago? Can we not spend billions of dollars that Congress has appropriated? Can we fire whoever we want? Those have, can we cut the Department of Education in half? Those have much bigger and I would say irreparable consequences than the ones from the first administration. And then the last thing I'll say, I know you were planning to get to this, so I might be preempting. Um,
Okay.
More so than ever before, the court is also now treating its rulings in these cases, even when it's not explaining itself, as precedents. Right? And that's really, really striking because for the longest time, the court insisted that these kinds of orders, even when they had brief explanations, were not precedential. And that was actually a way of relieving pressure from the court. Like, hey, if we mess up, we'll fix it later. Now, the court is saying actually these are precedents that lower courts are bound to follow. Kathy, even in cases in which they literally wrote nothing. And it's just, I think that was the move that really finally set off a whole bunch of federal district judges who, starting in like September or so, started talking to the press. And, we've heard over the last 3, 4 months more criticisms of the Supreme Court's procedural behavior without any regard to the bottom lines in these cases from lower federal court judges than I've ever seen before. Because I think the concern is that, the court has the raw power to do this. But by issuing rulings that have these massive effects, by doing it without explaining itself, and by nevertheless expecting everyone else to figure out what they meant, um, that's delegitimizing. One really good example of this. So there was a case from last summer about the downsizing of the Department of Education, a move that has consequences for all of us. And a district court had said, you have to stop, right? I have real concerns that you're doing this in a way that's illegal. The First Circuit, the federal appeals court, denied a stay, so it was still blocked. And the administration went to the Supreme Court. And in the Supreme Court, it made three different arguments about why it should get a stay. Kathy, one of the arguments was that these weren't the right plaintiffs. One of the arguments was that this isn't the right court. And one of the arguments was on the merits, we're allowed to do this. And the court granted the stay in a case called McMahon versus New York without saying a word about which of the arguments it was endorsing. So if you're the district judge in that case, if you're a district judge in the next case, right? If you're the administration, you have no idea whether the reason why you won in the Supreme Court was because they believe on the merits you can do this, or because you had the wrong plaintiffs, or because you just had the wrong court. The first two of those are fixable, right? That has become the norm in this context in cases that run the gamut of important subject matter, et cetera. And I think that's why you're seeing so much frustration and exasperation from judges on the lower federal courts.
And just so people know why you think that they might have precedential value now. Can you talk a little bit about maybe Justice Gorsuch and what he said that makes us start to think, well, maybe these do have precedential value and maybe we need to start looking at these and applying them to other cases.
Yep. So again, I'm going to cheat by putting a newsletter link into the chat. But
That's great.
the court, I mean, the full court, Kathy, in July had said something sort of cryptic on this point. And then in August, in a case about NIH grants, Justice Gorsuch had said, quite a lot about that indeed. And so what Gorsuch said specifically is he said, hey, lower courts, not only are you bound to follow our precedents, but he singled out, Kathy, three different district judges who he claimed were defying the Supreme Court simply by not treating as precedent orders that were never precedential. And so, the post I wrote sort of walks through his three examples and why they're all, if you'll forgive the scientific term, bunk. But, the Gorsuch concurrence was really, I think, I don't know, the apex of the Supreme Court's behavior on emergency applications, because it basically says, listen, we don't have to explain ourselves, but you lower courts, you have to figure out what we meant. That's striking. That's never how this has been understood before. And it also really, I think, absolves the Supreme Court of the responsibility, Kathy, to try to provide consistent rationales for what it's doing. I mean, we talked before about the disconnect between the Trump cases and the non-Trump cases. Historically, the Supreme Court's best defense against charges of partisanship or bias, right, or outcome-oriented decision making were its opinions, were the idea that the court would tell us, would give us, would write out principles, not because we would necessarily agree with the principles, but that we would at least agree that they are principles. And neutral principles is where the court's legitimacy would come from. The fact that we will apply the same rule when the plaintiff is this person versus that person, when it's a Democratic president versus a Republican president. Well, increasingly, we have this phenomenon where the court seems to be acting radically inconsistently based upon the partisan valence of the case and not telling us why that's not true. Right. So, I have a lot of friends on the left who assume this is all bad faith all the way down. I have a lot of friends on the right who say, the justices just have too many cases, too little time. And I'm somewhere in the middle, which is I don't know if it's bad faith or not. I don't care. It's bad for the court, right? And it's a bad look because it makes the court less, I think, institutionally sound. It opens it up to criticisms even from lower federal court judges. And Kathy, at the end of the day, the result is, right, that the current administration, for better or for worse, is being allowed to do lots of stuff lower courts have said is illegal without the Supreme Court saying they were wrong. And that's the real, sort of importance of the emergency docket at this moment in our courts and country's history, and also why it's become such a lightning rod.
Yeah, I think you just sort of eased into this common question that I'm going to ask. I have two kind of questions that we hear all the time from teachers, and then we're going to jump into the Q&A. So if you have a question, go ahead and drop it in the Q&A. But so this question about legitimacy, and does this, does what's happening that we've just discussed for the last 50 minutes, might that have an impact on the sort of everyday American or the legal community's perceived legitimacy of the court?
So, I mean, listen, we would need a couple hours, right, to really
Right.
sort of get into
Or
what
a
is
whole
the source of
course, right?
what is the Supreme Court, what is the source of the Supreme Court's legitimacy? I'll just say this. I think that any conversation about, first of all, I think the Supreme Court's legitimacy means different things to different audiences. But in almost any audience, I think part of the court's legitimacy comes from the belief that the court is acting in a manner that is principled. And, I think it's possible for the court to burnish credibility without having to show us its work. The problem is that when the output looks like it's, not based on principle, the opinions are the defense. Justice Barrett, I think, actually has picked up on this in her book tour in a speech she gave in 2022. She said, hey, don't take the media's word for it, right? When they call us partisan hacks, read the opinions. And, my response to her is great. Where's the opinion? It's like the old "Where's the beef" commercials, right? Again, like I may not agree with what the court's doing on the merits in a lot of these cases, but I agree that they're allowed to do it. The question is just, are you writing your opinions in a way that's persuasive? And when you're not writing at all, are you behaving in a way that's persuasive? And that's why this has become a conversation about the court's legitimacy, because so much of the court's behavior on emergency applications is both undefended and at least superficially, right, appears to be unprincipled.
Okay. And so maybe this goes into that question is so a lot of the criticism is how the emergency docket's being used. So would it be helpful to have clearer standards for its use? Is that something that's being kicked around and suggested?
I mean, there are already clear standards. The court has not in any of its recent cases repudiated what are really decades old standards for emergency relief. Kathy, the problem is the court doesn't seem to be following them. And so, my sort of simplest solution to all of this is the court should take it upon itself, right, to be impelled to write anytime it's going to grant emergency relief. And part of the writing should be a detailed explanation of why each of the factors that are supposed to go into emergency relief are actually satisfied. Um, that hasn't worked, right? We keep getting rulings where the court sort of nods toward the test for emergency relief, maybe, but then doesn't remotely engage with the factors or why they may or may not be applied. Really good example of this, Kathy, is a case from the fall about the Trump administration's new policy that if you are non-binary, intersex, or transgender, your passport must show your biological sex at birth. So that is a policy that only applies to new passports. It does not apply to existing passports. So the lower court said, listen, whether this policy is legal or not, the government can't show irreparable harm from blocking it because it's still letting anyone who has a active passport, a valid passport, walk around with the old rule, which was it can say you're intersex, it can say you're non-binary, it can say your gender identity if you're transgender. And the Supreme Court, Kathy, didn't even acknowledge that. It didn't talk about how the government wasn't really irreparably harmed. It didn't even look to the irreparable harm the policy was inflicting on those folks who needed a new passport. That's become the norm. And so I think an easy way out of this mess would be for the Supreme Court, Kathy, not to take fewer of these cases, because I think our politics are such that there are emergencies everywhere, but for the court to really commit to taking these cases seriously and to trying to persuade folks who might not already agree with the court that the answers it's reaching are the correct ones. I think that everything starts from what should be that uncontroversial principle.
Okay, quick answers to questions because we have a lot of questions all of a sudden and not a lot of time. So, how are the granting of the stays by the Supreme Court impacting their standing with lower court justices? I've been hearing of more frustration within the lower courts. So,
I mean,
quick answer.
we talked about that a bit. The answer is a lot. Lower courts are really pissed. There's not much they can do about it except express their frustration. But we are seeing a lot of that frustration. Um, and again, the power dynamic here is such that the lower courts lose, right? I mean, like in a fight between the Supreme Court and the lower courts, the Supreme Court's going to win every time. But I think the lower courts see it as part of their job to raise alarm bells when they see anyone acting in ways that are bad for the judiciary as an institution. And I think that's a big part of why you're seeing more and more district judges, Kathy, Republican appointees as much as Democratic appointees, making these kinds of public noises.
Okay, next, this is gonna be like the speed round. What happens if an emergency application needs consideration, but the court is not in session?
So the court actually is always in session now. I love this question. So in the old days of the one justice model, the court would formally adjourn when it would rise for its summer recess. And so actually, Kathy, the court was not capable of sitting between late June and the first Monday in October for much of the 20th century. If they had to, they would come back and have a special term, and those were rare. But today, the court is in session constantly. It's not on the bench, but the court can receive an emergency application at all hours. There was an important one the court decided last April, Kathy, at 12:54 in the morning on a Saturday morning, late Friday night. There's this joke that the court is not a Denny's. I don't know. I mean, I don't know about the pancakes, but it's never out of session, even if the justices are scattershot all over the country or the world.
Okay, I'm going to give you a frustratingly short time to answer this one, and this could be probably a lecture. Might the Supreme Court be tilting towards shadow docket rulings favorable to the Trump administration to avoid an outright scenario where the executive might blatantly defy a ruling on the merits?
This is entirely possible. I've called this the appeasement thesis, which, just one more time, I'm pasting into the chat. Right. This is perhaps the best defense that we've heard from folks on the right who are sympathetic to the court, but also troubled by its behavior, that the court's just playing for time. Kathy, there are two problems with that. The first is an awful lot of irreparable harm is being inflicted from these rulings in the interim, right? Folks who are being stopped by ICE, folks who are being removed from the country, grant recipients who are losing all their federal aid money, right? Like that kind of stuff those are bells that are going to be very hard to unring. And the second, just to sort of pick up on the appeasement point, um, appeasing a bully does not make the bully stop. And, I am not here to make any comparisons of the current administration to earlier administrations in Germany. But, right, if history has taught us anything, it's that all you do by appeasing a bully today is you make him stronger tomorrow. And I worry about how appeasement would, erode the court's power while enabling the executive's power for the confrontations that are inevitably to come.
Okay. Sadly, we are out of time. I wish we had like no questions in the Q&A, hardly any, and then all of a sudden there was a wealth. I just have a couple things to plug before we go. So we do write up a couple cases at the high school level each year that you can use with your students. And here are just some of the examples. Trump v. Slaughter, we talked about a lot tonight. That case actually was on the emergency docket, and then it was picked up on the merits docket. And so those are some great cases you can use with your students. And Emma's dropping things in the chat, I think, links. If you have not been to our Supreme Court Summer Institute, I know there are a lot of you on this call because I recognized your names in the Q&A, but please consider applying. It's very competitive, but it's worth the application, and it's a great 6 days taking a deep dive into everything SCOTUS. There is my email again. Please feel free to reach out to me if you have questions. Sometimes we get a question about like, could you have access to this PowerPoint? If you email me, I'm happy to send you a link to the PowerPoint. And that's just how to stay in touch with street law, which probably you already are, or you wouldn't have found this webinar. I definitely want to thank you all for coming tonight. It was a long day, whether you were at home with on a snow day with kids, or you had to teach today because you're in some place with balmier weather than us on the East Coast. But I appreciate it. And of course, I want to give a huge thanks to Steve, who is so very busy these days. Every time I see a newsletter or a podcast or, an article, Steve's name is there because everyone is knocking on his door for his expert opinion. And we are so thankful that you took time out of your evening after you put your kids to bed to be with us and to help us so that we can explain these really complicated things to students. And you may or may not know this, Steve, but sometimes the shadow docket is named in our textbook. I mean, if you look in the index, it's not even there. So now we have a better understanding, and we're really grateful.
I've got news for you. It's not in a bunch of law school textbooks either.
There you go. I did not know that.
We've been a little slow to pick up on the Supreme Court does stuff away from the marriage docket point.
Great. Well, thank you so much. I appreciate it so much. And thank you all for being with us. Have a great night.
Thanks, everybody. Thanks, Kathy.
Thank you.